We've done that a lot where we haven't actually clicked record. So anyway, good.
So, welcome back. This is the first webinar for a few months now, actually. We had a really busy end to the last year, and we had a really busy year in general with One NDA and all the new legal design projects that we've been doing. So we haven't really been doing these very much, but now we're back and we plan to do one once a month. So if you haven't signed up to our newsletter yet, please do, and we'll send you information when we schedule these. So the topic of today's webinar is how to build out a scalable legal function through design thinking principles. And this is what we're going to go through. First of all, strategizing for a scalable legal team. What is design thinking? Applying design thinking methodology to your function, and then design-driven quick wins. We know that everyone's really busy and you might not have the appetite or the time to go through a full project, a transformation project. So we're going to show you some quick wins today, which you can apply really easily, actually, so that you can start to scale the function. And as I said earlier, please don't be shy. There's a Q&A section at the bottom, a button at the bottom, and a chat function. If you've got any questions throughout the webinar, just put them in there. And if you wanted to have a chat with anyone who's in the group, please do. Okay, so before we start, we have put together this, this matrix that kind of describes the various types of legal teams we've seen. So the first is ad hoc. And there's a description in there, which is basically a legal team that just does things ad hoc because it hasn't really formed yet. The second is forming. So we see this usually in small legal teams where there are 1 or 2 lawyers and you're starting to form your function. The third is managed. Fourth is efficient. And fifth is transformative. And I appreciate there's a lot of information here, but when we work with in-house legal teams to help them structure their function, this is where we start. So we start by giving them a score. So if you could just take a moment and have a read, we're going to put a poll up in a minute and we'll ask you to tell us where you think your function is. Do people have had time to read it?
Oh, wait a moment. Okay. This is interesting.
So good. I love a poll.
Okay. A few more answers to come in. Okay.
Okay, so here are the results. So it's great to see that lots of you think that you fall into the managed area, because we actually think that most teams that we work with kind of sit between forming and managed. There's lots of ad hoc and forming, and there's 2 people that say that they are already transformative, which is the goal, right? And I think that we've been talking about this a lot lately, but I think that we've seen a massive change in the in-house legal function and how that's set up over the last kind of 5 years since we've been around. And we've seen that in-house teams kind of took the role of the risk aversion team, the team that's there to protect the organization. But slowly it's becoming clear that the role of in-house legal is more than that. And we're there to drive business, not just enable it, but drive it. And to do that, you need to set up a function that works effectively. And you can go from managed to transformative with just some quick wins. And hopefully today will help towards that. But there has been a change in the way that in-house legal is perceived, both by the business and by in-house legal themselves. So.
Sorry, I thought I was clicking in, yeah.
So sorry, as I just said, about 10 to 20 years ago, legal was seen as a risk mitigator. We had the big crash. I think that contributed towards that. And legal was rewarded for protecting businesses from risk. About 5 years ago, we started hearing in-house legal talk about legal as a business enabler and the function that's there to allow business to move forward. So it's not just there to say no, it's there to enable business and to understand what the business is actually doing rather than being siloed. So there was this movement towards in-house legal becoming more integrated. What we're seeing today, and we think it's because of COVID and the fact that in-house legal has, in a way, had the opportunity to be more involved with the business as a whole, because it's just easier to hop on a Zoom call than it is to be going into meetings. And from this might sound counterintuitive, but from the in-house lawyers that we've been speaking to, that's what they've been reporting to us. So they've really understood what the business is doing and the friction areas, and have taken a role of legal as a business driver, which is a massive transformation between what we were doing 10 to 20 years ago. Just to mention, and this isn't on this slide, now 25% of all lawyers in the UK are in-house, which is a huge leap from where we were before, where private practice was the standard route. So this is growing as a profession. I think we're structuring what that needs to look like in order for the function to be effective. And so in 5 years, we think that legal will be very firmly placed as a business leader, as I think it should be, because lawyers have got this different way of viewing the business. They've got an ability to take an eagle-eyed view of what's going on within the organization and to really drive decision-making at a senior level. So that's where we think legal will strive to be in the next 5 years. And we're already seeing rapid changes within the industry. So in order for legal to do that, it must pay attention to the processes it creates as to the actual delivery. So I think up until now, again, we may have thought legal is there to do law, but actually legal is also there to create processes, and those processes need to enable legal to have the space to do what it does best, which is add strategic value and empower other people in the organization to do some of the stuff that falls under the legal responsibility, and also to outsource effectively either to law companies or to law firms, but in a way that's governed and controlled. Otherwise, that management of that relationship will just take up so much time and you may not get the results that you need. So creating process is a really big part of your role as an in-house lawyer. And it's just as important as the law that you do in your day-to-day. So this is a meme that we kind of created, but tell me you're an in-house lawyer without telling me you're an in-house lawyer. So this is what you might feel like on a day-to-day basis. There's lots of stuff going on in your day-to-day. We think that lawyers in an in-house environment are probably some of the busiest people we meet, and there's just everything hitting you from everywhere. So it's really hard for you to put together the processes that are going to help you work in a more streamlined way because you're just so busy. And to create, you need space. So here are some stats as well to support the previous meme and some of the reasons for which you might feel that you're overworked. From some research that was done by the ACC, we saw that lawyers, there's only one lawyer per 100 employees, and less than 1% of annual budgets in businesses are spent on legal. And also 63% of in-house legal's workload is contract related. So that's really heavy workload. It's quite high pressure because it needs to close out, there's deadlines. So all these stats together paint a really clear picture as to why you might feel like the previous meme. So the point here is that you need to be strategic, not reactive. And in order to create a function that's really going to deliver on its promise and is going to provide the business with the support that it expects, then you need to be strategic. And the key to a successful legal function is to create tools and processes that successfully reduce your workload and empower others to take on non-core legal responsibilities without increasing risk. So the key to good process creation is design, which brings us to the very crux of this webinar today. And we covered this in a previous webinar, which you can find on our YouTube channel. But effectively, if you're an in-house legal team, you do need to be very strategic about what you do and also what you don't do. And the only things that you should be doing are the things that are high volume and high risk. Everything else can be given to either other people in your organization or externally.
Cool. Thanks, Alexa. So we need to talk about design. So before we go into how design can actually help build out your scalable legal function, we're just going to do a bit of background as to what design is and also how design thinking can be applied to your organization. So there's a bit of a common misconception about what design really is, and people often just think it's about making things look really nice. But actually what design is about is this. So design is about devising courses of action aimed at changing existing situations into preferred ones. Now that's a bit of a confusing statement, but essentially to translate what that's saying, design is all about creating solutions and problem solving. And it's not just about creating any old solution, any viable solution to a problem. It's about crafting a solution that is the most suitable solution to that need, and it's about addressing specific needs. So if we take Apple as the quintessential example of fantastic design, so obviously this is the iPhone, which looks really slick and really cool, but actually the reason that it looks like this is because it's designed to satisfy a specific set of needs. So the reason that it's so simple, and the reason that the design principles underpinning all of Apple's products are all about simplicity, is because Apple's trying to do something really, really complicated here. So if you take a step back and think about what Apple is trying to do as an organization, they are trying to get computers, which in the 60s, were the size of rooms, really complicated things into the hands of as many human beings as is physically possible on the earth, right? So they are the design principles that are underpinning the way that this looks, even though it looks really great. It's all about creating something that is as simple as possible so that every single person can use it. So it's not just some altruistic thing that Apple makes its products look like this. It's essentially to get its products into as many hands as possible. And, Apple is now $1 trillion company, so something's working for them. Here's a more modest example of design as well. So again, this is a Brompton bike, and people who live in London will probably see a lot of these floating around, but it looks really nice as a bike. It's a really attractive piece of kit, but actually it's performing a specific function, and it's designed for a type of user with a specific set of needs. So this is designed for a commuter, and you can fold up the Brompton and you can take it on the train, and you can take it on the tube. So even though it looks really nice, it's designed to perform a really specific function. And here's a final example of design. So this is an example of a project that we carried out for a client where we were redesigning their entire employee handbook. So obviously, on one hand, it looks really nice. So the form is really nice, but it also is performing really specific and important functions for the business. So on one hand, it's about creating something that employees can really understand. So obviously, it's really engaging in its colors, and the way that we've structured it, putting the key information up top and using infographics to really help employees understand what's going on. So that's one part of it. But the other part is that it's designed to reflect the employer's brand and what they're all about. By enabling employees to really access this information in a really simple way, it's showing that they are a compassionate employer who wants their employees to be able to understand what their obligations are and what their respective obligations are as employee and employer. And finally, it's going to reduce the workload on the HR team, really, because employees aren't going to be asking them all the time, what's this, what's that? They can just refer back to this and get the answers for themselves. So as well as sort of the more the fluffier benefits that come from this sort of stuff, there are some real tangible benefits, which is time saving for the rest of the business. So we just talked about finished solutions and what design can be, the outcome of design. But what about the process of getting there? So this is where design thinking comes in. So how do we actually get to those nice finished solutions that serve a specific purpose? So this is, we're going to go into the history of design thinking. So this is a guy called Herbert Simon, who was a 1960s economist, and he was a Nobel Prize winning economist. But he was really interested in social sciences, and his main field of study was looking at corporate decision making. And he was really interested in how companies as organizations made decisions. So he sort of posited that for every problem that a business has to solve, there are a myriad of solutions that they can choose from to solve that problem, but that not every way of solving that problem is good. So he thought, well, why can't we borrow from design and the creative process that designers take to solving their problems and apply it to corporate decision making? So rather than just taking an age-old solution off the shelf and applying it to an age-old problem, being more creative about how we think about that problem and how we solve it. So the inception of design thinking was really in the 1960s. And then moving into the 80s and 90s, this really kind of took hold, and businesses really started applying design thinking to their corporate decision-making. And IDEO, which some of you may be familiar with, is a really famous design agency, and that was founded in 1991. So what is design thinking? So design thinking is a process for creative problem solving. So it's all about taking a user-centric and human-centered approach. So you kind of, rather than starting with the problem and defining the requirements yourselves for what you think the way to solve it is, you start with the users and see what their needs are and what their issues are. And out of that, you sort of come up with various different solutions that could solve their problems. So you've really got to empathize with your users and step into their shoes. And it's all about creating fit for purpose solutions. So without knowing actually what the initial problem is from your user's perspective, you're not going to be able to create something that actually solves that problem. So in terms of our methodology and the general methodology for design thinking, so as I said, the first step is to really empathize with people and find out what their pain points are. And this is so important because often you think one thing is the problem. You think, oh, this agreement actually isn't working and we need to redraft it. But you go and speak to the users and actually the agreement isn't the problem. It's the whole process around it. The agreement is fine once they get to it. So you really need to work out what they're feeling and identify the problem properly. That is absolutely key. And we see that a lot where, oh.
Sorry, fire alarm.
I hope it's a drill. So once you've empathized with your users and really defined what your problem is, you can then start ideating. So this is about coming up with as many solutions as possible to fit the specific problem that you've identified. And the reason that you want lots of different ideas is so that you can prototype them out, which is the next phase, to work out which one would actually work in practice, which is best serving the user's needs. You then test it. So by prototyping, actually, I should say, you can do that using, just low fidelity prototyping. So using Post-its, literally writing it out on a piece of paper. It doesn't have to be anything fancy. Well, yeah, it doesn't have to be anything fancy. You can then test those things. So taking a real MVP approach to the ideas and the solutions that you've come up with. So rather than investing loads and loads of time and money in something, you go out and test the smallest version of the thing you can. And then you can iterate on it based on the feedback that you receive from users. So we'll go into this in a bit more detail in terms of the examples of this. Go on.
Yeah, I was just going to say, well, the empathize stage is really important because I think as lawyers, we're taught to draft contracts, and I'll use contracts as an example here, even though design thinking can be applied to your systems and the way you structure your team and everything. But the empathize bit is so important because we are taught that basically the person that's going to be using the thing that we're creating is a judge, when in fact, it's probably the business person. So it's important to take a step back and think about who you need to empathize with. Is this the judge? Is this really going to go to court? Are you actually going to litigate over your T's and C's? And if so, how often versus a business user? How can you get your sales team to engage with that contract or process or system? How can you create a team that's happy and motivated? And how can you make it so that the way that they're structured is serving the needs of the business? So actually identifying who to empathize with is probably the step that goes before the empathize bit.
Yeah, we should actually add that to this because that is key. And it's something we'll come on to later when we talk about tangible examples and you can see all the different users that you need to be thinking about. So here's just an example of design thinking in action. So Oral-B in 2016, we're looking to launch a new toothbrush. Obviously they're in the market for that. And so the corporate bods sort of sat around a table and thought, well, how can we make this toothbrush really cool and what people want to buy it? So they came up with lots of ideas. So for example, playing music when people would brush their teeth. I don't care about that. More lights when you're brushing your teeth, things like that, really, off the wall ideas. They brought in a couple of London-based designers to actually help them with this process and launch this new toothbrush. And the first thing that those designers did was went out and had a chat with people who use Oral-B toothbrushes. And all those people said, well, actually, it's really annoying to charge it when I'm on the go because I don't have any sort of USB charger and it always dies. So whenever I go on holiday, I can't really use my toothbrush. And also the heads wear out quite a lot. It's really frequently, and then I have to go and buy more. So that's also really annoying. So Oral-B took that advice on board and binned the let's make a musical toothbrush and launched a new toothbrush that had a USB charging port and additional replacement heads. And it was one of their best-selling toothbrushes. So it's just an example of where they would have wasted so much time and money launching this new toothbrush had they not actually spoken to their users. And this is something you could quite easily do within a legal team, particularly in sort of legal tech transformation projects, where you as a legal team might start defining all of the requirements in isolation of what you think that this tool needs to do and what you think the form that goes out to the business as a legal front door needs to say. And you spend all this time and money invested in creating this thing. You then roll it out and it just doesn't work because people don't understand the questions in the form, or people don't really understand the whole process. And it's about taking an MVP approach and also identifying your users and empathizing with what it is that they need.
And I think there's an element here where you need to fight your own instinct as a lawyer, because you are trained to always know the answer and be right. And you need to be prepared to be wrong, and you need to be prepared to be shocked by some of the responses that you get from the rest of the business. But without actually going through that process, which can be painful and also maybe, painful to the ego.
Exposing,
exposing, you could spend thousands and thousands on something that doesn't work. And we speak to so many people that have actually had that happen to them because the process was, I think this is the solution. This must be the solution. This is what people want. And if we just did this, if the tech's good, then people will use it. That couldn't be further from the truth. You're better off doing something really simple and cheap that people will engage with because you've asked them and you know what they want, rather than spending loads of time and money rolling out something really snazzy that no one's going to use because it doesn't fit the requirements.
Yeah. Exactly. Yeah. So design is all about keeping the people who are using your solutions at the center of everything that you do. Right. Let's get into it. Some practical examples.
So some practical applications of design thinking, other than, of course, designing your target operating model, which we haven't included here because it's a huge topic. So we've decided to tackle it in a separate webinar, just to give you a bit of context around what that means. A target operating model is effectively a plan that you create as the in-house legal team that outlines what you're doing from a strategic perspective, but also from a process perspective, and everything's documented, and you can then use that, iterate on it to deliver your strategy for the year. So as I said, we'll talk about that later in a later webinar. But to begin with, there are certain things that you can do to really streamline the way you operate that have design thinking principles at their core. So the first, and this is probably the top tip for any legal team that wants to scale, is a legal front door. We see lots of legal teams that take their instructions from just so many different channels, Slack, Teams, email, in the kitchen. It's really difficult for you to manage your workload if it's not all coming through one channel. So creating a legal front door front loads effort. It allows you to triage effectively. So you're not just doing the work of the person that's shouting the loudest, you're actually taking time to think about whether this work is business critical, whether it needs to be done at all, whether it can be given to someone else. And it also allows you, and this is so valuable, you can capture data. So if you have a legal front door for a while, say 3 months, you will know at the end of those 3 months what the number one request was. Is it data protection? And if so, can we do something to minimize those questions? Can we just give people some training? Or are people always asking us about the blurb that goes into a marketing email? If so, can we create something standardized and roll it out so that we can reduce those questions? Without that data, it's really hard for you to make decisions. So you want to get to that quickly. The second is playbooks. So having a playbook, especially when it comes to your contract reviews, that outlines your standard positions and what you do if those positions are either not met or there's pushback from the other side, is an amazing way for you to basically get rid of a lot of the work, considering that 63% of the workload that comes into legal is contracts. You want to get rid of that workload as much as possible if you can, but without increasing risk. So by creating playbooks, you're empowering more junior legal staff to take on the work. You can even ask procurement to get involved with NDA reviews, for example. Commercial, you can review contracts without increased risk. And also you create consistency across your contractual landscape, because if you're always taking the same position and you get DD'd at the end of the year, then your contractual landscape will be more consistent. The third is a knowledge hub. So how many times have you answered a question that you've answered before? And how good would it be if you could save those answers in a knowledge hub and allow people to query it before they came to legal? So that's another way for you to do that. Document design is so effective because you reduce negotiation time and effort. It also builds customer trust and it minimizes disputes. If people understand what the contract says, then they're less likely to do something that's not in accordance with it, including your internal people as well. You can redesign your negotiation process, which empowers the business to project manage commercial negotiations, which is something that usually falls onto legal, even though legal is stretched and doesn't have budget, and you're ending up doing a job that lots of other people in the organization can and should do. So if you create a negotiation process, then that will allow you to alleviate yourselves from those types of work. And finally, you can look into your platform user journeys, which will reduce your customer queries and negotiations. So we'll show you an example of this later. So we're now going to show you a quick video of what you can build on Jira, which is a tool that lots of teams already have. So Jira is an IT ticketing system, and we use it a lot to help legal teams create a legal software.
Hi, I'm Claire, head of product here at TLB. I'm going to show you quickly how we can use Jira to create a legal front door for your business to submit contracts to the legal team. Okay, so firstly, this is what the business user will see. Okay, so what can we help you with? Request a contract review or submit a question to legal. I'm going to take you through the request a contract review flow. Here we go. Raise this request on behalf of me. What team are you from? So I might say product. Who's the other party? I might say Google. What is the contract type? An NDA. What would you like us to do with the agreement? These can be anything. We can pre-populate these, but this is what I've put in before. What's the value of the agreement? £20,000. Will you share any personal data with the other party? Yes or no? Now, the great thing about this is you're really front loading the questions. So legal won't have to kind of go back to the business user and ask loads of questions. When legal gets this ticket into their Kanban board with the contract, they'll have all this information. So they'll be able to really hit the ground running. Anyway, let me carry on. If your answer to the above question is yes, what type of personal data will you be sharing? Will this data include customer and or employee data? I'm going to say no. And all of these are totally customizable, all of these fields. Has a PIA been completed? Yes or no? No. Has the budget for this been signed off? Yes or no? Yes. Is there anything else we should know? Free text, so they can put whatever they want in here. And now this is where they would attach the contract. So let me grab a contract. Got a signed one NDA here, so we'll put that in there. Wait for the contract to upload. Great. So then as a business user, I would submit this. So here we go. This is a preview of the ticket. You'll see that notifications are automatically on. So if someone, when someone picks up this ticket, I'll get notified. I can turn that off as a business user if I want to. And the contract has been attached. I can, if I want to, also add a comment. If I forgot to mention something that I want legal to know, I can add that in here. So now let me show you the other side. So what legal will see. So if I refresh this, this is our dummy board for this demo. Cool. So I've just received this new ticket. This is the one that we just created. This is coming here, the bottom of the board, in my to-do column. So what you'll see is if I open up the ticket, it's got all of the form entries that I submitted. It's got my attachment here. I can make an internal note, so I could reply, kind of make a note for my legal team, or I could reply to the customer, which would be the business user. And I can also assign it. So I could assign this ticket to someone in my legal team. And if I wanted to, I could create the time that it needs to be done within. Okay, that's everything. That's the legal front door. Thanks.
Thanks, Claire. So that's just an example of what you can do on Jira, but you can actually do this on things like Google Forms, SharePoint, Airtable. There are so many tools out there that will allow you to create forms and also seamlessly attach with a backend that you can use as your workload management system. You don't really need to spend loads of money on expensive tech when you already have things in-house that you're probably already paying for. The advantage of using existing technology is that there is no adoption. So the business is already there doing their other stuff on these platforms. So integrating legal within that system is a really good way of not spending lots of time trying to get people to understand what the system is. It also doesn't paint you as a team that sits in silo. You're part of the business. And we're not saying that there isn't room for specific legal tech. We're saying that it's best to start with an MVP, which is Jira, and then when you outgrow that because your team's huge, for example, or you have really complex specific needs, then you can consider something more specific, but you have the experience with a piece of tech that will give you the ability to set out your requirements before you go and procure that system.
Cool. So the other area that design can apply, obviously, is the information design piece, which we discussed earlier. So information design is all about presenting legal or other information in a way that's easy for the user to understand. And that who that user is, as we talked about earlier, depends in various circumstances. So it might be another legal user, it might be somebody you're actually negotiating against, in which case you might want tighter language, or it might be a child that you're creating a privacy policy for. So you really need to think about how you're actually drafting that and how it looks for that person. Here's an example here of one NDA, and I'm sure a lot of you are familiar with one NDA. But the way that we've designed this, because we did some user research before we started the whole process, and we found that 75% of respondents to our survey of sort of over 200 people said that the people who are using NDAs, as we suspected, are business users. So the idea was to make it as simple as for them to use as possible. So the only elements of one NDA that are actually variable are up the top. And you have 4 variable sections, and it's for the business stakeholder to populate that, essentially. I mean, obviously legal can do it as well, but it's just designed to be really simple for them. There's no negotiation. It's just those 4 variables, and all they have to do is fill out a form, essentially, and then send it off, and away they go. So this sort of design, we've seen people report a 19% and higher than that reduction in time to signature, because people just sign this because lawyers can understand it, business stakeholders can just self-serve and use it. And it starts commercial relationships off on the right foot. So this is a really facilitative document. And by sending somebody something, particularly a lawyer on the other side, a really turgid 30-page contract that's really complicated and cross-referenced all over the place, it just starts the commercial relationship off on a bad footing. And really, you want those things to be getting off on the right foot so that you can negotiate it, close the deal as quickly as possible, and so the business can start cracking on with what they want to do and ultimately make more revenue for the business.
And just on that point, I don't know about you, but lawyers are people, and when they receive a document that's disgusting, they have an emotional response to that. And that emotional response, whether we like to admit it or not, will have an impact on the way that they review the contract. So if you're considerate with your drafting, if you're considerate with your templates, then you will make your own lives easier. So it is worth taking the time to think about the other side and how they would respond as humans, even though we might think, well, they shouldn't. Well, they do, because they're humans. So yeah, we've negotiated some really terrible agreements in our time. And
just to go back to the user point earlier, so it's a spectrum depending on what sort of organization you are and who your users are as to how far you want to take your information design. So for example, if you're Monzo, so Monzo's mission is to make money work for everyone. So their terms and conditions really need to speak to everyone. So they have a one-page online terms and conditions, which has the reading age of 11, because that's who their users are. And they're quite happy, presumably, to take a level of risk on that, because the risk that they're trying to guard against is they're not trying to chuck the legal book at it, because the risk they're trying to guard against is that the consumer doesn't understand what their product does, right? They're not concerned about that user coming for them in a big litigation. So it doesn't have to be the most legal heavy document in the world, because it's about what issues are they actually trying to guard against with that. An example here also is Salesforce further along the spectrum. So Salesforce's consumers, or customers rather, are going to be big corporates. So they obviously want their agreements to be quite tight in terms of you know, the level of legalese or how sort of tight the obligations are with the counterparty. But at the same time, they are negotiating with big organizations, and they want those negotiations to go as smoothly as possible. And these are people they want as their customers. So as Electra just said, you don't want to be flinging over a contract to a prospective customer that the lawyer on the other side just thinks this is an absolute nightmare and my business is going to hate me because this is going to take me 6 months to negotiate. So it's in their interest to create something that reduces their negotiation timeline so that their salespeople at Salesforce can hit their quarterly targets. I'm sure everyone's received a contract like one of these where, you know, it needs to be closed by whatever. Anyway, yeah. And then another example. So, you know, Goldman Sachs, if they've got a big loan agreement that got in place with their borrower, then that's going to be even more legal again. But that's not to say they couldn't apply legal design principles to help a borrower, for example, understand what their obligations are. So, for example, if you have conditions precedent or conditions subsequent in that transaction, maybe they could use some infographics. So a corporate borrower who isn't necessarily totally familiar with the details of the documents could look at it and see, okay, well, if I do X, Y, and Z within this infographic, then that's going to be an event of default. And therefore I need to be careful not to do those things. Whereas hiding them in, you know, lots and lots of text can be really difficult to read. But just to say, depending on who it is who's using it, that's how you design these documents.
Playbooks. So playbooks are just such a fantastic tool for so many reasons. So firstly, I don't think that we spend lots of time thinking about what the commercial position is in relation to certain terms. So take term as a good example here. This is a playbook. And basically what it does is it sets out the company standard for that specific provision. So whether this is your own template because you have your product and you sell your product on the basis of your own T's and C's, or it's a third-party agreement that you review because you procure lots of stuff, then what's your company standard? I don't think we ever kind of take a step back and think, what's our company standard? You might just hire a lawyer and that lawyer has their own risk appetite and they review a contract and then they discuss it with you casually, you know, do you think this is reasonable? But you never actually take the time to document it. But if you do document it, then everyone in the team knows what the position is. There's no tension when you're reviewing a contract because you just know what the position is and you know how far you can take it in terms of negotiating it. So as a junior lawyer, especially, I remember always thinking, God, I don't know, is this all right? Probably. I'll ask someone. And then, you know, you're always asking them. The other thing that you can do is through your experience negotiating agreements within your organization, you can set out what the possible issues are. And this is an iterative document. It's a live document that you maintain. And every time a new issue arises, you can document here what it was and then what the company position was, which again, you'd agree with your GC or with the senior in-house counsel. And you say, okay, our company position is this. And then the other thing that we always say is that when you're reviewing a contract, when you're making amendments to it, you should strike out whatever it is that you're striking out or add your changes, but you should always explain why you're doing it. Because if you don't, and it is quite annoying when you receive a document full of red lines, but no rationale as to why that red line was included, you want to say why you did it. So we provide a canned response. You can provide a canned response so that you're not constantly thinking about a really good justification for why you just deleted something. So this just saves time and it creates consistency, and it also creates thresholds. So is this negotiable? Yes, cool. What's your fallback position? It's this. And what's the canned response if you get a pushback again? It's this. And what happens if you need to escalate it? Well, this is the person that you need to escalate it. And it's not always legal, because this could be, I don't know, something to do with payment terms, in which case you would escalate to finance. So this is not just a bank of clauses. This isn't just, what's the company position? It's a user journey. And what you're doing here is you're thinking of the lawyer or procurement, if you want to create one for NDAs and give it to procurement, whereby they are going through a journey whilst they're reviewing the contract, and it gives them parameters in which to negotiate without stress and also without increasing your risk profile. So a playbook is a very good use of your time and an investment.
Cool. So Electra also mentioned the negotiation process earlier. So often, I'm sure you've experienced this, is that legal ends up project managing an entire negotiation. But our approach, and everyone's approach, should be that just because it's a legal document doesn't mean that legal needs to own the process end to end. So this is an example of a process that we implemented for one of our clients, where we found that legal was just getting sucked into these things and having to deal with the whole thing end to end. So this was all about putting accountability onto the business owner, and ultimately they have more skin in the game in getting it over the line. What often happens is that legal is on the hook for collating all these responses from all these different teams. So what we did is made the business owner, we created a deal doc where it had all of the different areas of the business in there that would need to input into the contract. So for example, InfoSec needs to feed in on whether or not the organizational measures and technical measures set out in there are acceptable. Finance needs to feed in to tell us whether or not these are the commercials as agreed. Are they happy with the payment terms? Commercial needs to feed in to make sure that their commercial deal is reflected. And it was the onus is on the owner of the document to get all those responses from people, and then legal just takes them and does their thing with the document and gives it back to the business owner, who would then engage with the supplier. And we did a similar exercise with the supplier and had a live document with them. And when you use Google Sheets and interactive documents like that, it's really helpful because you can both be in there updating in real time. But ultimately, the accountability sat with the business owners to get this thing over the line and organize all the relevant calls. And we found that this reduced the negotiation timelines by 30%. And we had some really positive feedback from the business owners, because ultimately when they are on the hook, they are really pushing it forward rather than just chasing legal and feeling like something is going in a black hole because legal has other priorities and this thing isn't their main priority. Whereas for the commercial person, it really, really is.
Yeah, and what was really interesting about this project was that when we talked to the business owners, the deal owners, the commercial people that were driving the deal with the other side, they didn't know that they could own it. They thought, oh, well, this is a legal thing. Well, no, actually, it's not. This is a commercial thing, and you need lots of stakeholders to input into that process. So when you give them that power, when you empower them and you say to them, if you do it this way, it's right, then you'll see and may be surprised at how eager they are to take that on, because it's in their interest more than anyone else in the organization to get this done. And they don't want legal to own it necessarily. Some of them might do, but lots of them don't. So going through that process of really seeing what the commercial leads thought was a really enlightening part of this project.
Yeah, I think that is a really important point, actually. And people don't really want legal to own it, actually, because they feel disempowered, I think, in my experience of this. And just on that as well, signatures often sit with legal, but ultimately you do not need somebody who's legally trained and is that expensive to use DocuSign. You don't need to be legally trained to use DocuSign or whatever other signature tool there is. So that's another really quick win. If you don't want to do this whole negotiation process, just pushing signatures to somebody else in the business, ultimately it's an operational thing. So that would be a really quick win.
Yeah. Okay, so this is, I mentioned earlier, you can amend or you can work on creating a better user journey for your platform. So some of the work that we've been doing lately involves actual product design. So a recent one that we did said that they had a 75% drop off at sign up because basically the T's and C's were just very complicated. And also they almost encourage negotiation with their user journey. So we mapped out this, the first bit here that you'll see, we mapped out what the user journey was. So you'll see all the various steps. And this was just to get the contract signed. This wasn't even to fill in more details for the whole platform. This was just to get the contract signed. And the reason they did that is because they started up as a small organization, and they got lots of external advice from various lawyers that advised them in quite a risk-averse way. And so what they did is take on that advice and build out parts of their products so that they wouldn't be non-compliant. But then a new GC came in and they said, you know, this is ridiculous because legal is getting in the way of deals. So let's find a way to make this more streamlined. And so we created this flow instead by talking to their users and understanding what the friction was and where they were encouraged to do things that weren't kind of, you know, advantageous for the business. And what we did is we reduced the steps by 75%, and we saw an increase in 30% on conversion rates. So that's huge. Your T's and C's journey can actually be a barrier to sale. So that's something to consider when you place yourself as a business driver within an organization. And just to leave you with a quote from a rich, privileged white man, strategy is simply resource allocation. When you strip away all the noise, that's what it comes down to. You cannot be everything to everybody. So strategy is about placing your resource cleverly and making sure that you've got enough resource and time and headspace to do the stuff that really matters, and channeling your energy and the time that you have available to you to create things that are going to allow you to scale. You can spend 15 minutes reviewing an NDA, or you can spend 15 minutes designing a form that you send out to the business to use as a legal intake channel, and the latter will gain you much more time. So if you change your mindset to think, what are the things that I can do that will save me time, and what are the things that are just sunk time, I think that is the key to creating a scalable legal function. Any questions? So we've seen quite a few questions come through. Yeah, so the first question is, doesn't this make you less approachable as legal? It makes the relationship harder. I think that's a really common concern. The concern is that if you create a process, then that kind of makes you less approachable, and you're putting barriers between you and the business. Basically, without putting any barriers, what will happen is that you don't have any boundaries, and it's really hard for you to manage your workload. It's really hard for you to be as effective, because basically what's happening is that everyone's just hitting you from everywhere. So a legal front door is not something that makes you less approachable. I think if you look at other teams within an organization, they all have a process. And so that's, you know, that's not a reason for you to not think about better ways of working. People are asking for a copy of this presentation. We will publish some of it, yes.
There's this one here as well.
How do you deal with a sales team that does not want to take ownership of the commercial contracts? Well, I think, Patricia, I think you want to understand why and what that means. Are they afraid? Are they afraid that they're not going to be able to do it properly? Are they overworked? Do they have too much work? Why don't they want it? And how can you incentivize them to take the contracts? And it might be that actually it's not appropriate for them to take the contract. So I think really getting to the bottom of why, what their reservations are and what their fears are, is the best way forward to understand.
How do you deal with requests from senior members of the organization in terms of the front door concept? Interesting. Yeah. I think it depends on, you know, who they are. And yeah, I think ultimately if the CEO needs you to do something, then you just do it. Yeah. But it depends, because if it's, you know, a run-of-the-mill NDA type thing and it's not something that's urgent, then try and push them through the front door, because that way you can triage it properly within your team, and so you're assigning the right type of person. Otherwise, if things go outside of the process, then it just will ultimately slow you down.
Or maybe their EA can support with that, if they have that support.
Just seeing if there's any other questions in here.
Asim saying, it feels like the concept of legal front door has been around for years. What do you think is behind lack of adoption by teams? I think it's the concern, Asim. I think it's the fact that lawyers might think, well, if I introduce a front door, that I'm forcing people to engage with the process before they can get in touch with me. And I think that creates resistance. But if you design a front door that will benefit the business, because it actually means that their work will be done quicker, they can check where their work is without having to rely on you to give them an update. And if you really take that design thinking approach when you put it together, i.e. understand what they want and what it is that you could do to create a front door that will be a benefit to them, then I don't see why it won't be adopted. We've worked with plenty of companies that have adopted it, and it is by far the most effective thing that you can do as a quick win.
And I think the other reason why there may be lack of adoption historically is that I think when new lawyers enter a team and they haven't necessarily, the broader team hasn't had exposure to lawyers before, you want to really embed yourself in the team. So you want people to over communicate with you, and then sort of backtracking on that as time goes on, as you start to make your legal function more sophisticated, it can sometimes be a bit more challenging to then introduce that sort of that barrier, if you like. So that's potentially another reason why there has been in maybe historic lack of adoption. But as Electra says, it really is the quickest win out there.
Yeah, for sure. And how to get buy-in, we'll have a separate session on how to get buy-in, because I think I don't think legal doesn't know these things and doesn't think that they're good ideas. I think that there is a lack of buy-in from the business, and it's about driving that adoption across the board. And it is, again, design thinking is the perfect approach for this, because at the end of the day, they're people, and you want to get them to understand that, first of all, this is going to benefit them, but secondly, there are certain things that they want to avoid. So appealing to people's fears and pains is actually a much more effective way of getting them to do something. And I know that sounds really manipulative, potentially, but it is the way to drive change. And if you read about change management, there are lots of studies that show that if you focus on the negatives, that's actually much more effective than focusing on the positives. So if you're trying to get finance to engage with something, and I'm using that because it's quite a simple example, if you say to them, you're going to save money by doing this, and you're not going to have to be embarrassed next time you stand up in front of your CEO to talk about the budgets, things like that. That might be a simple example, but look at the fears of the person. If the fear of the sales team is that they're not going to get the deal done as quickly as they'd like, then use that and say, look, this will be done quicker. All those times that you've been chasing me, this won't happen again if you're using this legal front door.
This is an interesting question. So how do you make the commercial team accountable? Because the reason that it usually comes to legal is to make sure those teams don't go rogue. I mean, I would say to that, what evidence is there of them having gone rogue in the past? And I think if it is on their head, be it from a CEO or risk perspective, then maybe they wouldn't go rogue if they understood the implications of what they're doing. I think making people accountable, involves setting up the right processes and procedures for them to follow. And if they go outside of that process, then they've gone outside of the process, and it's really not on legal, provided you've set those right parameters in place.
And I think this is where you need senior buy-in, right? If you can find support internally that basically allows you to place that accountability onto the commercial or the sales team, then that's great. And you need that. And it's about kind of mapping out who you need to get buy-in from, and then following that journey before you then hit the sales team with a new process. Lena's asking, would the playbooks be open for anyone in the legal team to edit? It's up to you, really. I mean, what we do in our team, because we have a master playbook that we use for all the contracts that we review, we have a sheet at the end that anyone can edit, and you can add recommendations. So, for example, I've seen this come up. Can we add a canned response for it? And so that's open to everybody, but not the rest. Do you view the success of some of your projects as dependent on any parts of the organization, like procurement, finance? And if so, how do you deal with the scenario with other departments are not moving at the speed of tech and process change as the legal department is? Yeah, this is clearly a huge topic, right? How do you influence people, and how do you get buy-in? So it is about navigating the actual people, and sometimes it's about getting really granular and finding that one person that if you get them on side, they're going to be able to influence other people within the team. And that person might not always be the most senior person. It could be someone who just has influence because of their personality. So it's about really understanding dynamics within a team and approaching the right people at the right time with the right message. So tailoring your message and mapping out who you're going to approach is really important when you're driving change.
See if there are any other questions. Any other questions? There's loads of interesting chat going on, so thank you for that. Everyone offering advice to other people, which is really great to see.
Okay, well, if there are no other questions, thank you very much. Yeah, just let us know if you have any other kind of follow-on thoughts from this, and we'll circulate a recording so that you can share this with your teams. But thank you so much.
Thanks so much. Bye.
Bye.